All right, let's dive right in. Welcome to this explainer on human rights law. Today, we're tracing the entire architecture of human dignity. We're going to journey all the way from its ancient philosophical roots right up to binding modern Indian jurisprudence. Let's find out exactly how abstract, high-level rights actually transform into concrete, enforceable realities. Here is our roadmap for today. 1. Concept and evolution. 2. Global and regional frameworks. 3. The absolute bedrock of Article 21. 4. Pills and expanding rights. And finally, 5. The protection framework. Let's kick things off with Section 1, Concept and Evolution, the philosophical origins of human rights. So here is the absolute crucial takeaway, right off the bat. Human rights are not gifts. They're not privileges gracefully granted to you by a king, a sovereign state, or even a constitution. No, they are inherent to all human beings, simply by virtue of being human. They're universal, they're inalienable, and they're deeply interdependent. In India, this exact concept is explicitly legally recognized under Section 2D of the Protection of Human Rights Act 1993, which defines them as rights relating to life, liberty, equality, and dignity guaranteed by the Constitution or embodied in international covenants. Now, this definitely didn't happen overnight. It was a massive evolution. You can actually trace the early concepts of formalized justice all the way back to Hammurabi's Code in 1750 BC. Fast forward to 1215 AD, and the Magna Carta finally steps in to restrict absolute royal power. We see civil liberties dramatically expand with the French Declaration in 1789. But, the modern era truly begins in the tragic ashes of the Second World War. The horrors of the Holocaust catalyzed a massive global consensus that led to the UN Charter in 1945 and ultimately the Universal Declaration of Human Rights, or UDHR, in 1948. That was literally the very first time a global standard of human dignity was boldly articulated for the whole world. Legal scholars find it really helpful to categorize the evolution of these rights into 3 distinct generations. It's kind of like a progression. The first generation focuses on civil and political rights. Think of these as your core liberty rights. They protect you from state interference, like your right to free speech and a fair trial. The second generation shifts the focus to economic, social, and cultural rights. These are equality rights that actually require the state to take positive action, like providing access to education and healthcare. Finally, we have the third generation, which represents solidarity rights. Emerging post-1970s, these recognize that communities collectively have rights to things like sustainable development and a healthy environment. Moving right along to Section 2, Global and Regional Frameworks, translating philosophy into binding treaties. Okay, so in 1966, the UN basically split its focus and created what we call the Twin Covenants. On one side, you have the ICCPR, enforcing first-generation civil and political rights. This is a big deal because it creates immediate binding legal obligations on states to protect fundamental liberties right now, like the right to life under Article 6. In stark contrast, you have the ICCSR, which guarantees socioeconomic rights like housing and health. But here's the catch. It operates on the principle of progressive realization. This means a state has to implement these rights gradually, using the absolute maximum of its available resources. Look, you can't magically build thousands of hospitals overnight, but under this treaty, a state must prove it is actively working toward it. Now, how do these global ideals actually get enforced? Well, they are usually handled at the regional level, but as you can see, the enforcement strength varies wildly depending on where you look. The European system is basically the gold standard. It's highly developed, and the judgments from the European Court of Human Rights are fully binding. The Inter-American system is known for being incredibly strong on indigenous and gender rights. The African system is quite unique because it deeply recognizes those third-generation collective people's rights. But take a look at the Asian system. It unfortunately remains pretty underdeveloped, relying on declarations without any strictly binding human rights treaty holding it together. Within this whole international framework, we absolutely have to acknowledge international humanitarian law, or the laws of war. Now, this is distinct from, but obviously overlaps heavily with, human rights. The 4 Geneva Conventions of 1949 strictly govern armed conflict. They lay down rules based on the core principles of distinction between combatants and civilians, proportionality in attacks, and military necessity. Running parallel to this is the 1951 Refugee Convention. This treaty enforces what is arguably one of the most critical concepts in all of international law, the absolute principle of non-refoulement. That is the ironclad guarantee that a refugee will never be forcibly returned to a country where they face severe persecution or danger. All right, let's funnel this down to the domestic level with Section 3, the bedrock, Article 21. Let's see exactly how international standards integrate into the Indian Constitution.
I want you to pay close attention to this exact phrase because it literally revolutionized Indian constitutional law. Procedure established by law must be fair, just, and reasonable. Let that sink in. It is no longer enough for a state to simply pass a piece of legislation to take away your liberty. The actual procedure of that law must be fundamentally, demonstrably fair. But how did the courts arrive at this monumental conclusion?
Well, let's deconstruct it step by step using the Firak method on the landmark 1978 Maneka Gandhi case. Here are the facts. The government arbitrarily impounded Maneka Gandhi's passport without giving her any reasons whatsoever. The court issue before the Supreme Court was whether the procedure restricting her liberty under Article 21 needed to be fair and whether fundamental rights operate in silos or are interconnected. The rule the court laid down was earth-shattering. Procedure cannot be arbitrary, it must be fair, just, and reasonable. In its application, the seven-judge bench overruled previous, much narrower views and officially linked Articles 14 for equality, 19 for freedoms, and 21 for life and liberty into an interconnected golden triangle. The conclusion? This case famously introduced substantive due process into India. It is, without a doubt, the undisputed foundation of all modern Indian human rights jurisprudence. Next up, the 1986 Olga Tellis case. This brilliantly illustrates how the Supreme Court expansively interpreted this newly supercharged Article 21. The facts: pavement dwellers in Bombay faced summary eviction, which would completely destroy their only means of survival. The issue: does the right to life under Article 21 actually include the right to livelihood? The rule established by the court here was incredibly profound. They stated that the right to life is far more than mere animal existence. It absolutely must include the right to live with basic human dignity, and you can't have dignity without a livelihood. The application meant that while the state absolutely could evict encroachers, it could not do so summarily. It had to follow strict due process, giving proper notice and a fair hearing. The conclusion is massive. It effectively pulled those second-generation socioeconomic rights directly into the legally enforceable, justiciable realm of Article 21. Which brings us to Section 4, PILs and expanding rights. Public interest litigation as a tool for systemic justice. You know, a right is really only as strong as your access to enforce it. And that's where the Supreme Court sparked a revolution in the late 1970s, spearheaded by visionaries like Justices V.R. Krishna Iyer and P.N. Bhagavati. They developed public interest litigation, or PIL. By radically liberalizing locus standi, they ruled that any public-spirited individual could approach the court on behalf of marginalized people who simply couldn't afford to do so themselves. They even introduced epistolary jurisdiction, which is wild. It meant a simple handwritten postcard from a prisoner could be treated as a formal writ petition. Using extreme procedural flexibility and a tool called continuing mandamus, the courts basically kept cases open indefinitely to continually monitor the state's compliance on huge systemic issues like bonded labor, under-trial conditions, and environmental destruction. The 1997 Vishaka case is a perfect example of the sheer power of a PIL when combined with international law. Here are the facts. A social worker was tragically gang raped, and because India literally had no specific workplace harassment laws at the time, women's rights groups filed a PIL. The issue was complex. Could the Supreme Court just step in and invent binding guidelines in the total absence of parliamentary legislation? The rule the court applied was that international conventions India had ratified, specifically CEDAW, could be read directly into fundamental rights like Articles 14 and 21. In its application, the court didn't just suggest rules, it laid down the comprehensive, legally binding Vishaka guidelines to protect women at work. The conclusion perfectly showcases India's monist approach, successfully incorporating international human rights directly into domestic law via judicial interpretation. And those guidelines stood rock solid until the POSH Act was finally passed in 2013. Finally, let's look at the machinery itself in Section 5, the Protection Framework, the Protection of Human Rights Act 1993, and the NHRC. Recognizing that the courts simply couldn't handle every single human rights violation in a country as large as India, Parliament stepped in and enacted the Protection of Human Rights Act in 1993. This act built a very comprehensive three-tiered enforcement architecture. At the very top, it created the National Human Rights Commission, or NHRC, for central macro-level oversight. Below that, it mandated state human rights commissions to tackle localized issues. And quite uniquely, it directed the establishment of designated human rights courts in every single district, complete with a special prosecutor to ensure speedy trials for very specific human rights offenses.
Now, the NHRC is meant to be a heavyweight institution. It is strictly headed by a retired Chief Justice of India or a Supreme Court judge. While inquiring into violations, the NHRC actually flexes the robust powers of a civil court. It can legally summon witnesses, demand public documents, and receive hard evidence on affidavit. However, it is structurally bound by some pretty critical limitations. First, there's a strict time bar. It cannot investigate any event that occurred more than 1 year prior to the complaint. Second, and perhaps most importantly for enforcement, its final recommendations are not technically legally binding. Now, state governments do face immense moral and institutional pressure to comply, but at the end of the day, they are just recommendations. But this naturally brings up one of the most contentious friction points in all of human rights law. What exactly happens when severe allegations of human rights violations involve the military? Can the NHRC even step in?
To answer that, we have to deconstruct the 1996 Paramjit Kaur case. The facts? The NHRC attempted to investigate the horrifying large-scale disappearances of youth in Punjab, which immediately raised huge alarms over military jurisdiction. The core issue was squarely focused on Section 19 of the Act, which explicitly restricts the NHRC's direct inquiry powers over the armed forces. The rule the Supreme Court affirmed was fascinating. They said yes, direct inquiry is limited, but the NHRC is fully empowered to demand and heavily scrutinize comprehensive reports from the central government regarding the military's actions. In its application, the Supreme Court aggressively backed the NHRC. They declared that the government simply could not ignore the commission and was bound to respond to its findings. The conclusion here cemented the NHRC's institutional weight, proving it holds wide de facto authority even in the most highly sensitive systemic cases involving the armed forces.
And there you have the whole shebang. From the ancient carved decrees of Hammurabi to the sweeping global declarations of the UN, all the way down to the meticulous Farak law of the Indian Supreme Court and the robust mandate of the NHRC, we have mapped the entire architecture of justice. And if there's one thing that is absolutely clear, it's that theoretical rights mean absolutely nothing without rigorous domestic enforcement to transform them into lived everyday realities.
So, I want to leave you with this final, provocative thought to chew on as you continue to study this space. The international laws are codified, and the domestic frameworks are solidly built. But as our society rapidly shifts and changes, is our enforcement machinery truly agile enough to protect the ever-evolving standard of human dignity? Thank you so much for joining me on this explainer, and remember to keep questioning the frameworks around you.